Ciao a tutti. This is Prof. Joe at Prof. Joe Explains. And tonight we're going to look a little more closely into the Aaron Spence murder trial that's coming up, the background, the context, the players. So that we'll be ready when the trial starts. And it's right now scheduled to start on June 22nd. We'll see what happens. And our guest tonight, I'm very pleased to say, is a fellow law professor. He's teaching criminal law now, teaches securities law, was a clerk for the Third Circuit Court of Appeals, which is a pretty prestigious, gig to get from law school. And he also is a columnist for the Arkansas Democrat-Gazette. So he gets to write his opinions and be read by a world of people who don't read our law review articles. And he is the law school is maybe 30, 40, maybe an hour from where Aaron Spence lived in Arkansas. So as he told me just a moment ago, you can't live in that area and not know about this case. So we're really going to be able to get some great context and great information for somebody who has, as they say, boots on the ground. So without more, let me introduce Professor Robert Steinbuch from University of Arkansas at Little Rock. Welcome.
Hey, it's so great to be with you, Joe.
Yeah. Is there anything you want to add to what I just said? Because feel free.
Just as you know, of course, for all law professors and columnists, my views are mine alone, not necessarily of the school for which I work. But other than that, great. Thanks for the nice introduction.
Okay, and I should have said that. It was on my piece of paper, but I get taken with the sort of the flow of my own words sometimes. So, what I would really like to do, if it's okay with you, is to take us back to before the shooting, to the point at which Michael Fossler was arrested for sexual crimes related to Aaron Spence's. I think at the time she was 13 years old. And Can you tell us a little about the crimes and the arrest, and maybe a little about Michael Fossler himself, because there's been a lot swirling around, in the internet and elsewhere. And so it would be great to have some solid factual information.
Albeit, in looking at the screen that you put up, it's mostly what I know about Michael Fossler. And let me elaborate in a sense, right? And that is, here's a guy in his 60s that had some sort of relationship, I'll put in air quotes, with Spencer's daughter. He was arrested, charged with sexual crimes. He was released on a rather low bail by the trial court judge up there. The trial court judge also issued a gag order in that case that was reversed by the Supreme Court. Then fast forward, so Foster's out, right, because he's out on bail. And fast forward, and we'll talk about the events, of course, of Foster's killing, but fast forward, and guess who Spencer winds up initially before as his trial judge? The same trial judge that was in charge of Fossler's case.
And that was what I was going to ask you, if it was the same judge. So it was.
It was initially. The Supreme Court removed her from the case when she also put in some sort of gag order, some restriction on the attendance at Spencer's trial or the preliminary hearings. And she restricted access to the public and to media. That went up to the Supreme Court, the state Supreme Court, of course. And the Supreme Court not only reversed her, but they removed her from the case. In Arkansas, the Supreme Court has what's known as a superintending authority. They actually have more authority over trial court judges than the U.S. Supreme Court has over federal trial court judges, because our Constitution has a somewhat recent amendment empowering the Supreme Court to control essentially entirely all lower courts. And they removed her from the case. Incidentally, you might find it interesting that they cited to a previous case in which they removed a judge from a case. And that was a case in which I was both the plaintiff and one of the attorneys. And we had the judge in that case removed from the case. And it may be the first time that the court used its superintending authority to remove a judge from a case, because they cited to that case, not a prior case. So
Do
just
you know
kind of
what
a
her
small world.
background was? Do you know where she went to law school, or what her background was before going on the bench?
I don't know.
You don't.
No, I knew at one point. I mean, our trial court judges overwhelmingly have gone to one of the two state schools here, but I don't know if she has. And they have a little bit of practice, and then they take the bench. But her orders in this case, as well as in the Fossler case, were viewed by many as highly unusual.
Yeah, and I looked. I think his bond was 50,000, but he only had to pay 5,000. He didn't have to pay the
Right.
full amount. Yeah,
Right, because in many jurisdictions, including Arkansas,
10%. Yeah,
that's right, because you get a what do they call a bail bondsman, and you give bail bondsman 10%, and then they front the rest. And so it was an insignificant bond, and everybody asked, how could you put out such a low bond?
Now, I know what I've been reading is that he was in some level of law enforcement in an adjoining county. Do you know if that's true? Had you seen anything about that? Because I've seen quite a few reports saying that.
I don't know. I know very little about his background, in fact.
Okay.
But yeah, that's all I can say is really I know very little about his background.
Okay. And so he's arrested and charged, and there are several counts. It was stalking. It was sexual interaction with a minor. There were several counts of child porn. There were some with, I don't know whether it would be called internet stalking, but that level of crime. So there were many, many counts. I think 43 total that I had seen in a couple of reports, counting everything.
Well, and that's precisely right. Like, I don't know the number, but I'm precisely right in the sense that it was a large number of crimes, and they were all sexually related crimes, but none of them sort of the simple, I put in air quotes because it's not simple, is maybe not the most apt word, but a simple rape charge, meaning they were all these sort of sexual ancillary crimes, but none seemed to be sort of the direct forcible rape that, of course, does not distinguish it in terms of its moral awfulness. But my point simply is it was a number of complex crimes in which he apparently was establishing some sort of just awful relationship with this young girl. And then engage. Yeah, right. 13 years old. And the reason I bring that up, I want to make clear for two reasons. One is not to suggest that they are any less morally offensive. Maybe in some regards, they're more morally offensive. But I bring it up because there is something perhaps rare about Arkansas law. I know it exists in other states, but not in all states, and that you can use self-defense or defense of others, of course, if someone's life is threatened, but you can also use it if someone is engaged in certain felonies, and rape is one of them. But these other related sexual crimes are not one of them. So the point being is, when Fossler has Spencer's now 14-year-old daughter in the car, it's not, we can't jump to the conclusion that he was engaged in the crime that would automatically allow Spencer to use deadly force. He was engaged in horrific crimes previously, but none of which, to the best of my knowledge, automatically allowed the use of deadly force.
Okay, and I don't know Arkansas law as well as you do, but one of the counts was adult sexual assault of a minor. Minors can't consent. So in Arkansas, the sexual assault with a 13-year-old may not be may in the sense of there's a chance that it's not characterized as rape in Arkansas for purposes of self-defense or defense of other.
it's right. So it's a different type of rape. It would be a statutory rape, right? Which is, again, an awful crime and one that can give rise to a huge penalty, but it's not one of the specified crimes for self-defense, because self-defense has an immediacy component to it, coupled with, I forget the terminology, but essentially immediacy and violence. And the thing about statutory rape is it's non-consensual because of the age, not because of the use of force, right? In other words, if someone uses force against a 13-year-old and has sex, that's forcible rape. That gives rise to the ability to use self-defense or defense of others automatically. Statutory rape doesn't automatically give rise to the use of self-defense or defense of others. That's
so you say automatically. Let me let me focus on that a little. Does that mean that it is possible that it would be covered, but there would be an issue at trial as to whether it would be available to him as a defense of others defense, or it's not possible?
It's not the defense of others for statutory rape alone is not available, but there's always the option to use defense of others if the other's life is in danger or that other is threatened with severe bodily injury, SBI, as we like to call it.
But that's the other. That's the other. But with regard to the rape, the statute is clear. It has to be forcible rape. There wouldn't be, you don't think there's any way for that to be interpreted to cover?
Well, I'm not going to say that anything, there's never a way, right? But sort of what several states, including Arkansas, does is they have the core notion of defense of others, which is to protect the life of the other or to protect the other from severe bodily injury. And then we, in some other states, add into that certain felonies. Kidnapping is one. The question here is that kidnapping in this case?
Right.
Forcible rape, the high level, high level is not the best word, but forcible rape is another one. Statutory rape is not one of those crimes that puts you in the category of automatic use of self-defense or defense of others, and therefore you default back to life of the other or severe bodily injury to the other.
Okay. And this could be kidnapping, so that would fall within kidnapping if it turns out to be.
That's correct.
Kidnapping.
That's correct.
And I don't know enough about kidnapping, interpretation of kidnapping generally, and certainly not in Arkansas, as to whether kidnapping, it would constitute kidnapping if it's a 13 or 14-year-old, even if she went consensually.
Right. I think that's the issue. And I don't know precisely how that plays out in criminal law in Arkansas, but that's going to be the issue on the kidnapping is, if she volunteered to come, does that constitute a kidnapping or some other, again, I'll put lesser crime in air quotes, right? Because and maybe it's perhaps simply apt to call it lesser in the sense that the punishment tends to be lower, right?
Yeah. Well, it'll be interesting. I'm going to look at this a little because it seems to me the other argument there was he was under a no contact court order in that case. Right. And I assume that a good lawyer would be able to weave into a kidnapping claim the fact that he was not in a position legally, he was under an order to stay away from her. Right. That's an interesting, we should write a law review article here. This one seems really interesting, even if nobody read it but us.
But you touch on an important issue when you say we should write a law review article, because I get a lot of questions from folks saying, well, isn't it this, or can't you argue that? Right. And the answer is maybe, right? What people, it's almost challenging even for us as lawyers in that, we're in 2026 and you mean all these questions haven't been answered yet? And the answer is no, they haven't been answered
that's
yet.
Right. Well, they don't come up.
That's right.
Or they're not raised because you're a prosecutor and you don't know what the answer is, and you think you have enough good other evidence. You're not going to introduce a potential appealable issue just to get the law straightened out in a particular area.
That's exactly right.
I wouldn't do it as a prosecutor, and I assume you wouldn't do it as a prosecutor.
That's right.
Okay, well, let's leave that then, because
Yep.
we don't know what the answer is, and we're getting into very technical legal territory and even trying to deal with it.
Right.
So Fossler is arrested, he's charged, and then he's released on a $5,000 bond. And I guess I would say, if I were a parent and this person was charged with these sorts of crimes against my daughter, and with a $5,000 payment, he's back out, I would not be a happy camper in the community.
Oh, indeed, right? And I think in general, that was the sentiment. It was certainly my belief. I was amazed that he's out on a $50,000 bond on which he only had to give actually $5,000. And to demonstrate how ineffective that bond was, because, when you issued a bond, it not only is a promise to show up in court, they also attach all sorts of other requirements, like no contact with the victim. And sure enough, that's precisely what happened. If Fossler was in jail, he wouldn't have been able to have contact with that victim, with the 13.
And not incidentally, he'd still be alive.
Indeed, he would be. That's exactly right. That's exactly right.
So, all right. Do you know, I'm going to have to check this. Do you know how long he was out before we don't even know if he made prior contact with her, but between the time he was out and the time that he made contact again with her?
I don't know. I don't know precisely, but I can tell you that it was not a long time, because all of this sort of was happening, and we had even heard about his Fossler's case, obviously before Spencer killed him, because that was news in and of itself. The fact that they had this bond for such a low amount was in the news. And then, like I said, in Fossler's case, as well as in Spencer's case, there was some issue about trial publicity that that judge was involved in. And I can't remember the precise parameters, but that trial judge was sort of getting in hot water in the Fossler case, even before she took on the Spencer case, which now she, of course, no longer has.
It's interesting that, having presided over Fossler's case, that she would end up presiding over the trial of the parent of the victim in the other case. It seems to me if I were an assignment judge, I don't think I would let that happen. It's just rife with problems. So,
well, I would say this, and if I were she, I would have recused. I would say, well, I've got the other case. It doesn't make sense to me also have this case, although I guess the other case goes away once Fossler's dead. But yeah, I think I would have recused from that case, from the latter case, from the Spencer case.
Yeah, and the defense did move to have her recused, and then, of course, they moved to have her dismissed from the case. And I haven't looked at, I've got the documents now, but I have not had a chance to read them as to whether one of the grounds for the recusal was her involvement in the prior case with Fossler. All right. She also, I thought, made an interesting ruling with regard to the expert witness that the defense wanted to call on the behaviors of victims in situations like this, and particularly young victims, and the grooming aspect. Were you following that at the time?
I don't recall that ruling, so I can't say, but I can say that she had been generally antagonistic towards the efforts of the defense in this case.
Yeah. What she did was exclude that witness testimony, at least at the first ruling, which also struck me as, let me say, remarkable, because it seems to me that these days the ability for the defense to bring in a witness to try to explain what would otherwise look like odd conduct from a victim, and particularly a child victim, is pretty routine.
And as you well know, Joe, the standard now for the admission of expert witness testimony is considered rather low. If in any way it can provide aid to the jury through that expertise, and the person really doesn't have to meet a particularly high threshold for expertise under the current standard of law, it's supposed to come in because the jury is supposed to be the one that decides how useful it is. The only reason the judge should keep it out is if the expert doesn't meet that minimum threshold and it's not a high bar, or if it's confusing, a waste of time, or unfairly prejudicial. And those are rather hard bars to chin.
Mm-hmm. Well, before we leave her completely, are trial judges in Arkansas elected or appointed, or is it a Missouri system? So how does it go?
It's a pure elected system. It's not a Missouri system, which, as you know, is a appointed and then election just to renew, or the federal system, which is a pure appointment system. But I do like to point out, people say, well, that's rather political. It's all political. The question is which system of political.
What type of politics?
That's right. That's exactly right. And sometimes I think that I'm confident that each system has their benefits. And I also believe no one system is entirely superior to the other.
Do you know when she's up for re-election?
I don't know. The circuit court position is I always forget, it's either a 6 or an 8-year term, but I don't recall when she was elected. Okay. And then we have a cap, actually, an age cap, effectively, of 70 years old for the court. You can't run after, you can run after you're 70, but then you lose your whole pension. So judges don't tend to do that.
But she looks pretty young from her picture.
Yes.
That's not a recent picture, so I don't think
she is young.
Yeah,
it's not good. She's young, and I think your producer put up on the screen earlier that she went both undergrad and law school to University of Arkansas at Little Rock, which is where I teach at the law school, the Bowen.
So you must have colleagues who remember her.
I would guess so. Yeah. I mean,
you weren't curious enough at lunch to ask them who knows this judge and what's she like? And I mean, you're failing on the job. I can't believe it.
Well, in more ways than one. But I'll tell you that this is a topic of much discussion, less so at the law school than in other places. So that's the funny part, is that at the law school, there's less of a discussion.
Is it? Because I would find it the kind of thing that I would be talking to my colleagues about just on the legal issues. Why the bond? How one can decide to exclude the expert. What is the likelihood that the law with regard to defense of others might cover this? There are so many legal issues in there without getting into let's call it the quote unquote gossip on the facts.
That's right. It's true. But we have some very different sort of focus of attorneys. You have a criminal law background. I teach criminal law. I've got a couple of colleagues that teach criminal law, but most folks don't have any involvement in criminal law at the law school. And so it just doesn't, at least randomly, hasn't come up when I've been around. But I'm often not at the law school too. I kind of in the community more.
Okay. All right. So Fossler then is released. He evidently, from what the news reports are, goes to the house where Spencer is, where his daughter is. Have you ever seen it? But I'm going to take a side tour now. Ever seen a picture of his daughter? Is she an old-looking 13-year-old? I don't mean obviously. I mean mature. I
understand what you mean. I don't think I've seen a picture of her, and I think that's by design of the media. I think the media has avoided putting her picture up. Yeah.
So anyway, somehow he either by prior arrangement has arranged for her to leave the house, or he gets in through, but who knows what happens. But he goes off in a truck with her, and Spencer evidently knows something about the kind of car or truck that Fossler is driving. Otherwise, he wouldn't have been able to identify, I don't know how he'd be able to identify the truck on the road.
Well, that and apparently he's got, like the family tracking on the phone with the daughter. So he becomes aware that the daughter is out of the house, and it's like 2:00 in the morning or something. It's crazy time for a 14-year-old to be, or frankly, an adult as well for that matter, but certainly a 14-year-old to be out of the house. And so he starts chasing down the daughter and Fossler in Fossler's truck.
So potentially, I'm sorry to interrupt, but potentially then he was able to follow because of the phone and not because he identified the truck. That makes more sense. I don't know.
Right.
Actually, yeah.
Right. Okay. Right. That's what I've heard, is that is one possibility of how he was able to get behind her and him, get behind the two of them. And at some point, and he calls the police, and I think they try to wave him off, so to speak, over the phone, and he refuses. And I don't blame him, right? If his daughter's in a truck with someone who is being charged with abusing her sexually, no less, then you're not going to wait on the police, I think, or at least many people wouldn't wait on the police to try to keep track of her. And he chases her down. And then, now this is the question, what happens next? Right? We don't know. The prosecutor went on TV, or these days what we do, I call TV too. So sort of some sort of media, because I saw the clip, and he said, well, he got out of the car, the Spencer did, and killed in cold blood Fossler. Now, I'm amazed that the prosecutor did that, because it strikes me that that's a violation of judicial ethics. He's not supposed to be pleading his case to the public in that fashion. But that's the question. What happened next? Spencer has not, sort of, to the best of my knowledge, revealed a full accounting, because he doesn't have to reveal a full accounting, right, of what occurred. But my understanding from speaking with various folks who are closer to either the lawyer or to Spencer is that they are claiming he acted either in self-defense of himself or defense of his daughter. And sure enough, Spencer kills Fossler.
So what do you know about the truck? Evidently had some sort of camera in it. Law enforcement sees the camera and it's been lost.
Oh, is that right? I heard something about a camera, but I didn't know that there was this narrative now that, we don't know where it is. Isn't that interesting?
That's what I read. I mean, I understand. Right. I am quoting news sources that are out there. Right. I don't know that I've seen an official document, but that's what I have read, that it's not around anymore.
Yeah, that's interesting. That's interesting. I think what's actually going to come into play, as you likely know better than I do in this case, is what we call jury nullification, meaning the facts strike me as going to be somewhat important to the jury. And then even if the facts don't support Spencer having a defense, being able to use either self-defense or defense of others, because there's no dispute that he used deadly force. So one could only use deadly force either in self-defense or defense of others. The question is whether the jury will dismiss that concern, given the overall big picture that Fossler had Spencer's 14-year-old daughter at 2:00 in the morning in his truck. And I think that's going to be a real issue in this case. There's another
being charged with. I mean, this is not a case in which the parent believes that someone is sexually abusing his daughter and goes after him. This is a case in which the parent at least has some reason on the record to believe that the individual has sexually molested or abused his daughter, which seems to me to be different from most cases here. That you'd say.
That's exactly right. And that's one distinction. And then the second distinction is, it's not like Spencer just went after Fossler. Fossler has Spencer's 14-year-old daughter in the truck 2 o'clock in the morning. So there is this sort of exigent circumstance, whether that sort of crosses some legal threshold as it intersects with the issue of defense of others is going to be at play here. But certainly it's not just Spencer interacting with with Fossler in a way that even that alone could give rise to some sort of jury nullification. But this is a much tighter fact pattern in which we're not only dealing with jury nullification possibility, but the intersection of that with some vague or lack of clarity as to precisely what happened at the moment that Spencer confronts Fossler on the side of the road at 2 o'clock in the morning.
Right. I saw, and again, I have not seen official documents here yet, that Spencer may have fired the gun 15 times, that the Fossler may have been hit 15 times. And also there was some information earlier that had been reported that maybe at the bond hearing that Spencer had said something to Fossler about, I'll get you, some comment like that at the time. I'm trying to think of the side, because the question for me is, on facts like this, what would lead the prosecutor to bring second-degree murder charges? And I have faith in prosecutors that they bring a case that they think, can be proved beyond a reasonable doubt, and then in good faith they believe should be brought. But you look at the facts as you have them, and it leads me to think it seems as though there must be more. And I can build. Go ahead. Sorry.
I was just going to say that, as I mentioned earlier, when Spencer is chasing down Fossler that night and he calls the police on his way and they try to wave him off, he obviously resists because he doesn't get waved off. And he made some comments, and I don't know what they are, and therefore, or I don't remember precisely what they are. And so I'm not going to sit here and kind of try to put them together. But he made some sort of comments that he'll take care of it, something along those lines. Again, I'm not even comfortable. Let me make it clear for your audience. I'm extremely paraphrasing because it's relevant, right? It's highly relevant. But I think the prosecution is relying heavily on that. And I think you can't put a lot of weight in whatever he said there, because one's comments are not going to be precise when in such a context. Now, let's make a counterfactual. If he called them and they said, try to wave him off, and he said, no, I am planning on stopping him, pulling him out of the car, and assassinating him, yes, even in that context, those words would be critical. But the words were not like that. They were clearly much more general. But I think the prosecutors put in a lot of weight in whatever comment he made. Spencer, made to the police as he was chasing them down. And it's really, the side story is when this all started, he gets arrested by the sheriff because of the area.
He being Spencer?
Spencer gets arrested by the sheriff, meaning, if you live sort of more out in the country, there's more sheriff than there is city police. We have city police departments all over the place. And then we have sheriffs that have sort of broader jurisdictions. Sheriffs, of course, can make arrests inside cities as well. But in this instance, the police force happens to be the sheriff. I point that out because Spencer then runs for sheriff during this time against the sheriff that arrests him and wins. He is he's the, I think it was a primary, but I don't, probably a Republican primary because Arkansas is overwhelmingly Republican. But my guess is there was no Democratic candidate even for sheriff in that area. So whoever won the Republican primary is the presumptive forthcoming sheriff. And that's Spencer. Spencer won that.
So he won against the sheriff who made the arrest. See, I knew I knew he was running, and I knew he won. I think he's got an independent now running in the general election.
Okay, gotcha.
All right, see, I can see the side for the defense that the prosecutor would have to look at. That the guy's already molested his daughter once. He's taken him again. He's chasing after him. He's not going to wait for the police. He's in, an emotional state. He says, I'm not going to wait for you. He shoots him 15 times, which seems to lean towards not self-defense because, you would have immobilized him at that point, but he's just, now he's really in a heated emotional state. So I can see the case that the defense will bring on it. But again, from the prosecutor side, prosecutors don't bring cases that are, very, very difficult to do. And I don't think prosecutors generally bring a case where they're hard on the facts, and there's going to be a lot of public sentiment going the other way. I'm not suggesting that they lean towards public sentiment, but this just doesn't seem a case that one would reach out to prosecute. And I come back to the prosecutor deciding to bring it anyway. And so the question is, what on that side is the evidence that pushed them over the line and pushed them over the line to a second-degree murder charge and not maybe a manslaughter charge, because they brought it, pretty high level charge.
It's a great question. Of course, I don't have the answer to that, and it's one of the questions that many people are asking. Spencer has a very good attorney who's been doing criminal law for many years, a woman by the name of Erin Casanelli, excuse me. And she is, she's solid. And if I point that out to simply say, not only is it curious that the prosecution brought this case, they are up against a real professional when it comes to criminal defense.
Yeah. And I'm not in favor of vigilante justice ever.
Of course.
But this one is not a run-of-the-mill vigilante justice case. You rightly point out the father didn't go after the victim afterwards. The Vossler created the circumstance out of which it occurred, and he'd already been charged and then released. It's a very different fact pattern, and it's just a little hard for me to see. And I'm more than willing to believe that the prosecutor has that other evidence, and it just has not been shared yet. But let's go to the gag orders. Do you know if the Arkansas Democrat Gazette either intervened at the trial to argue against the closing of the trial, or the gag orders that really effectively prevented anybody who had any possible connection with the case to talk about anything related to the case?
Right. Just bizarre. I don't know. I'm on the opinion side of the paper because I write a column. And so I don't know. It would be the news side that would have done that. And I don't know if they intervened in the case. I tend to write columns, that is, that are kind of bridge that. I do what I call investigative columning. There's no such word, of course, but my columns tend to be fact-based, and I do actually independent research on many of them. But we're not the ones, sort of generally, our side of the street are not the ones going out and bringing lawsuits for intervention into the court, or even Freedom of Information Act lawsuits, albeit I've contemplated doing that in conjunction with the paper before. It never needed in the end, because I've got an expertise in the Freedom of Information Act, and so folks tend not to be too resistant to me.
Right. I will say, with all respect to you, that you're just not a very good gossip. You don't talk about it among your colleagues to find out what they might know. You don't talk at the paper about why they didn't intervene to file a motion against what the judge was doing. This is really, my colleagues at the law school are much better gossips than you are.
Well, I've learned from working at the newspaper and doing many interviews with good interviewers like you that you get into dangerous territory when you start repeating that gossip. So even had I heard it, Joe, I'm afraid you wouldn't be able to draw it
Oh
out
gosh.
from me.
Well, then I'm happier that you don't have it, because it would be really
Right.
frustrating if you had it and didn't share it. So I
That's
feel
right.
better about this now. It
Right,
is
right.
surprising. I mean, it's not inexpensive to have a lawyer go in and do that. But this
Right.
seems to me to be one where the news outlets would have been very interested in making an appearance and stating the position of the
Right.
free press for what these orders were doing. And I mean, I teach criminal law and criminal procedure, but First Amendment law. And it seems to me that what the Arkansas Supreme Court said about the overbreadth of the orders was
Right.
entirely accurate.
Right.
One of the biggest cases in this area was Stewart versus the District Court in Nebraska. Uh, and this U.S. Supreme Court, and this order seemed much broader. She didn't make
Oh,
any findings as to why it was necessary, no findings as to why anything lesser would have worked. As I read the order about the public in the courtroom, the way she had limited it, it sounded as though no one from the public would be able to get in, or a very, very small number, because she was limiting family and media. Uh, and
no, it
it's
was
just hard
terrible.
to explain.
It, that's really the right way to characterize it, Joe, which is I have no explanation for it. I work in the realm of the Freedom of Information Act, which more broadly is we call it transparency law, and that also includes access to courts for the media, not under the Freedom of Information Act, but under the First Amendment itself.
And
And
six, both. Excuse me.
sorry.
And Sixth Amendment, both.
Oh, interesting. That's right. I hadn't thought about that, but that's exactly right. And so it's really remarkable. You sort of there was some gossip at the law school as to why one would issue such a draconian order in terms of a gag order in a case. Really unusual. Incidentally, I see a question that I think I saw repeated earlier. What's
Let me read it so that we'll have
yeah,
it for people who are listening.
yeah.
At what age of the victim is statutory considered to be force in Arkansas?
Well, I'm not sure it's considered force, but the age for statutory rape, I think in Arkansas is 14. But then there's other, like I think if what do they call that? I forget the name, but the spread of age can be a factor as well. But I think the anyone under 14, I think everyone that's always statutory rape, and then there are later ages depending on whether the individual is in a position of authority. Right. So a teacher can commit statutory rape against someone who's older, and other people in similar authority, including inside the household, right? Like
right.
That's a question that many people ask, and it's a perfectly legitimate question to ask. But it's like 14 ... right? 14, and then all of these other factors.
Yeah. And Lee, statutory rape really means that the victim is not old enough to be able to consent. You have to, for it to be consensual, you have to have voluntary positioning on both sides. And at certain ages, you are just too young in the law for you to be considered to have acted voluntarily. But that is not necessarily force in the law. Because force, if you think of a dictionary definition, is I put a gun to your head, I threaten your mother, those sorts of things. And it's not that. It's a statement that you are too young to consent. Even if you say, yes, please, I'm so happy, it doesn't matter. It's irrelevant because of your age. And so the issue that's come up here is if the statute reads to say forcible rape, it seems to exclude this area of non-consent. It would certainly exclude non-consensual sexual activity if the other person was an adult. but it
Right.
also seems to exclude it when the person is a child. And it would depend on if the statute is written tightly, it would be hard to get around it. I think that the more likely avenue, as you well point out, would be that maybe you could get it in under kidnapping.
Right. And of course, what we're talking about is whether defense of others would apply here. And we can't have the automatic defense of others merely based on the criminal violation of statutory rape. So there would have to be some other criminal violation that would trigger that, or, and one, of course, being kidnapping, or obviously a threat to either Spencer's or his daughter's life. Or a threat that Foster was going to commit a severe bodily injury to one of the two at that moment.
Right. So here's a question in the chat now, Christy Wolf.
Right.
Do you think the DA will drop the charges if Spencer is elected sheriff?
Well, indeed, he said quite the opposite, right? Once Spencer won that primary, which, as I say, effectively wins a race. You pointed out that there's an independent running, so that independent has a chance to win, but not a significant one. But the DA has already come out and said he's going. And in fact, the trial is continuing and will happen in, would you say, June, I think, right?
June 22nd, unless... Right. Because my guess is, and I talked to a lawyer about this last night, that with the new judge, if I were the defense lawyer, given the circumstances of the first judge being removed by the Arkansas Supreme Court, I would be pushing to have every one of the substantive orders that had been entered by the prior judge re-argued. And I'd also push to say, and there's no deference given to the decision the first judge made, we've got to do it as though there were no decision made at all and really do it de novo. And that, I don't know how long that would delay the proceedings. I mean, maybe they can get it, we're in the end of March now, they might be able to get that all done and still go on the 22nd of June, but it at least throws a monkey wrench into the timing.
Do you have the name of the new judge by any chance?
I had it and I don't have it here now. I didn't. I'm in Italy at the moment. And
my goodness.
Some of my notes are not here with me, and I had his name. I'm pretty sure someone in the chat will give it to us in a minute. They're very, they are very current on all these cases. So I would be
I got it. So
the defense didn't push for that.
Well, it's very interesting. So the new judge is a retired trial court judge by the name of Ralph Wilson. There you go. I appeared before Ralph Wilson on another case. Also, he was put in because it was a Freedom of Information Act case, but the plaintiff was a person that got on a lot of people's nerves. And so all the local judges recused themselves, and Wilson was put in. And I'll tell you this, solid judge, very good temperament, a smart guy, nice guy, didn't always rule in my favor. I'm not saying now I won the case, so I'm pleased by that, but didn't rule on every matter in my favor. But even when he ruled against me, I would never say that they were irrational, bad rulings. Just, there are many times, Joe, well, that a lawyer makes a motion, and we almost invariably really do believe that we should win when we make motions. It's very rare we make a motion saying, I shouldn't win this, but I got to make the motion. I mean, I think it's possible, but it's very rare. And certainly in this case, I believed every motion and every sort of position I took was right. And he didn't always rule in my favor. But I also believe that there are many circumstances in which you say, look, I've got the better side of this argument, but the other argument isn't terrible. I could see that perspective. And I think mine is better. But if someone sides with the other side on any particular issue, I say, I get it. I see where you're coming from. And Wilson really was down the middle, I thought, in his rulings, as they say, calling balls and strikes, right? Like an umpire.
Well, there's a question in the chat, and let me ask you a related question first.
Yeah.
Do you think the prosecutor should move for a change of venue? Get it out of this area completely? I mean,
I'm surprised they haven't, right?
Yeah, yeah.
Right. So it's usually the defense. I'm surprised that the prosecution hasn't. And I suspect it's a little late for that now. But uh, uh, yes, is the short answer. It surprises me. I'm not sure they should, but if I were the prosecutor, I would not want to prosecute it in the home venue, shall we say.
Yeah. Well, you would think that if since Spencer won the primary, now I don't know how many voters voted in the primary, that would give you some inkling. I mean, let me back up. My guess, without knowing any more, would be that a lot of those votes in the primary were votes in support of what he did with regard to the killing of Michael Fossler. That those votes were not independent of that. And then if that guess is right, you would think that gives some inkling of what the jury pool is going to be like in the county for this trial.
Indeed. Let's see here. Aaron Spencer got, according to what I'm pulling up, 5,400 votes. The incumbent sheriff got 2627, let's just call it 2,700 votes. And then a third candidate got 2,000 votes. So it's a total of roughly, 10,000 votes. And Spencer got a majority. And what's interesting about that is if you don't get them, this is a 3-person primary race. And in Arkansas, in virtually all elections, but there are a few exceptions, you need to win a majority, including in a primary race. For example, the U.S. presidency, or in fact, most federal offices, you just win a plurality. So if there are multiple people in a race, if you just win a plurality, I say most, I think all, but I'm not an expert. You win a plurality, you win. Certainly, we know this from the presidency. But you still have to reach that threshold. Well, no, I think you just win a plurality, even in the Electoral College. But in Arkansas state elections, you've got to win a majority. And if you don't win a majority, it goes to a runoff. And we actually have the runoff for certain elections. A sheriff in a different county, Saline County, for example, is in a runoff right now. And the early voting is today, in a few days. But Spencer, got a majority in a 3-way race. It's not impossible. We had that, for example, for a circuit court, which is a trial court here in Arkansas, a judge here in Pulaski County where I live. And it was a 3-way race. And the candidate that I happily backed won that majority. But it's pretty telling, to your very point, Joe, that Spencer beat 2 other candidates so well that Spencer got a majority of the vote, and there is no runoff. So I would not want to be a prosecutor in that county. Someone earlier asked, it's still up on the board. Tracy asks, hey, is there any conflict or bias? Well, I mean, it ain't good for the prosecutor, because the prosecutor is elected in the same county. So that goes to the jury pool, which is, of course, the question that you started with.
Yeah, and I just looked to see what the census or the estimated population is of that county, and it's about 77,000. But that's not just registered voters. That's children. That's people who would be excluded from the jury for a number of other reasons. That may be people who, So yeah, that's not a happy jury pool for the prosecution.
No, and it's if there's 77,000, and it's a very rough rule of thumb that we say, half are people who are voters. It's that's really very broad. So you're down to, like, let's say 35,000, and you got 10,000 to come vote in a primary. That's not a bad turnout. I mean, would of course like to see more. So it's a pretty strong reflection of the population, I would believe. So yeah, it doesn't bode well for the prosecution in terms of the jury pool.
Yeah. Well, it's going to be pretty interesting. I mean, to see how this plays out with the new judge, how many of those orders are going to be relooked at, what that will do to the scheduling of the trial. What will happen if some of the motions that the defense lost the first time, the defense now prevails on, which will also, you would think, affect the calculus of the prosecutor deciding whether to prosecute. And this case seems to have more nagging legal issues than many of these that you see. I mean, I can count 2 or 3 just sitting here. But I think the one thing that we should be pretty confident about is that this is going to be a much more public trial than the prior judge would have permitted, and probably, or I shouldn't say probably, but there's a reasonable chance that it's going to be much more public than even this judge might have decided to do before all of the issues with regard to public access and public trial. I mean, I read that Arkansas Supreme Court opinion, and I wouldn't want anybody to write about me if I was a trial judge the way that court wrote about her.
Oh, yeah.
They were pretty emphatic about open up 100%. The court. Yeah.
100%. They really, I mean, they slammed her. And like I said, they relied on a case that I litigated, in which the judge in my case was removed. And if you thought the language in this case was strong, you should have read the language in that case. Totally different case, mind you. It was actually an interesting case. It was a case about a statute in Arkansas that permits attorneys to carry guns in courthouses. And I litigated that and said attorneys, according to this law, are entitled to carry guns in courthouses, and no courthouse permitted it. And I litigated that successfully. And then it was remanded from the Supreme Court to the trial court. And the trial court said, well, it's going to be, a year. I'm going to have to study this, and I'm going to have to do some research, and I'm going to have bring in witnesses. And of course, the mandate for the Supreme Court said, go do what we told you to do. Mm-hmm. And he literally, I forgot the word he used, but he put on hold the Supreme Court's opinion. And I remember talking to a judge friend of mine, and I said, can a trial court put a Supreme Court opinion on hold, or whatever the word was, but effectively it was on hold. And it struck me as absurd, but I thought maybe I'm missing something. And my friend looks at me, who's a judge, and said, well, of course not. Why would? And I said, oh, okay. That's what I thought. But I thought maybe like I was absent that day from law school or something.
Tell me about this. I mean, because I could imagine if I were a judge, I mean, some of those trials are pretty heated, pretty intense, particularly domestic relations or child custody. Does the statute say you can bring them into the courthouse or in the courtroom?
You're so, Joe, you are so smart. I mean this sincerely, because the statute says courthouse and courtroom, but I only, wait a second, wait for it. But I only litigated courthouse because I knew there's an article, a separation of powers issue regarding courtroom. And so I only litigated courthouse, and then the Supreme Court on its own in Arkansas can issue what are called administrative orders. And I told you, the Arkansas Supreme Court has powers well beyond the powers of the U.S. Supreme Court within the state, of course. And they issued, shortly after they permitted it in the courthouses, I suspect some judges became antsy about the undecided issue of courtrooms, and the Supreme Court issued an administrative order saying judges get to decide courtrooms. And I know only of one judge that currently allows guns in the courtroom. There was another judge that allowed it and then changed his mind. No judge in the county in which I live, which is generally, even though Arkansas is highly Republican, the county in which I live is pretty Democratic. And I don't know of any judges in my county that allow guns in the courtroom. But the courthouses, that's fair game.
But I just think it's very true. In some of those courtrooms, you got victims' families and defendants'
Right,
families and,
right,
charged issues. And
right.
I think if I were a bailiff, I wouldn't like it at all. And if I were
I'm,
a judge, I
I'm
would be
sure.
worried about it. I mean,
Right, right, right,
do
right.
they have to? Do you know if the statute says they can come in with a concealed weapon, or does it have to be?
Oh, it's concealed. Yeah.
It's concealed. Oh boy.
Yeah. But you've got to identify. You've got to identify when you come in, of course, because you've got to go through an X-ray machine,
Yeah, of
whatever we
course.
call that, a
Yeah.
magnetometer. But mind you, people with a particular carry license in Arkansas are entitled to carry in the state capital itself. So it's the legislators do act consistent with the notion of what's good for the goose is good for the gander. So it's allowed there. It's not allowed according to the Supreme Court in the Supreme Court building, because the statute's written in a way in which arguably the Supreme Court building there's a distinction. I
Well,
don't
now,
necessarily think it's a good read, but
well,
nonetheless.
how's your history? Wasn't Huey Long shot to death within the Capitol building or within the
I
legislative
don't know.
chamber? Does
I don't
anybody
know.
in the chat know? I mean, this has nothing to do with the Second Amendment. I just do think
Right.
that some of these places are just so highly charged, and people are so emotional. And if you give them a half or hour, an hour to breathe, they wouldn't act the same way. But this was something I didn't know. So thank you
Yeah.
very much.
Sure. Well, I figured it would be a little bit of color for the interview because people don't know. Texas has it. I don't know who else has that, but it's unusual. And, Arkansas, don't forget, is a very, as we now call, red state, a very conservative state. And one of the aspects of that conservatism is generally a pro-gun or gun
Yeah,
permissive
yeah.
environment.
Yeah.
Yeah.
Well, I'm not taking a position on that generally.
I
It's
understand.
just
I understand.
within, because how charged those situations are, that
Right.
it just seems to be potentially asking for trouble. Well, okay, I've taken a lot of your time. Is there anything else about this case that I haven't asked about that you would like to share or tell us we
Well,
should be watching for?
in some respects, it strikes me you know more about the case than I do. So, no, because I'm afraid you'll ask me another good question for which I'll have to say I don't know. And there
Well,
were too
thank
many
you.
of
That's
those.
a great compliment, and I appreciate it very much.
Well, it's my
When you
pleasure.
teach, you don't get compliments like that from the students sitting in the classroom.
I know. They all know it all better than you. Don't they?
Yeah, well, I appreciate very much your time
My pleasure. Thank you.
and your ability to sort of bring some more context and light about this case. And I don't know, I think the people in the chat may be so flabbergasted by all of this that they have no questions.
No more comments. Well, we had several good ones.
You had
I
very
thought.
good questions.
Yeah.
Yes,
Yeah.
yes.
Yeah.
But I just think that some of what we talked about here, even for people in the chat who follow trials and are very knowledgeable about trials, some of this opens new territory in terms of how a trial might operate and what might happen in this one. I've been sitting here thinking that if the trial is postponed, for any length of time, and he's elected, and he won't be, I'm sure he doesn't take office until January. But if the prosecutor needs the assistance of the sheriff's office in doing things, I can see so many places where this will be, let me say, interesting. I mean,
Right.
I watch these trials, and murder is terrible, and the impact on families, both of even of the defendant's family, certainly of the victim's family, and of children, and it's just tragic. But I have a perverse interest in some of the oddities that come up, and some of the places where, you say life is stranger than fiction, that, you almost have to laugh at it because it's what the defendants do just defies any kind of reason. And this one opens a new door to not so much the defendant, but the way this one looks like it might play out will
Well,
certainly be
indeed. And building on that point, right? What's so fascinating about this case is nobody likes to see a killing. But we do distinguish between justified killing in self-defense, defense of others, and that category in Arkansas encompasses certain other crimes as well automatically, as we discussed, from unjustified killing, which is some form of homicide. Most people call it murder, but those are just some of them, not all of them. But, colloquially, we call it murder, and more particularly, we call it homicide. And indeed, I happen to be Jewish. I only mention that to say that if you look at the Hebrew version of the Ten Commandments, many people interpret the prohibition on killing as not that the word in the Ten Commandments is not "thou shalt not kill," rather it's "thou shalt not murder." And so I bring this up to say this is precisely the case that draws out that distinction. What is really what society takes as so horrific? And of course, murder is what society takes as horrific. And murder and other killings, justified killings, self-defense and defense of others, we believe to be sad but appropriate, because the alternative is a harm to an innocent. And all of those moral issues are at play in this case.
I agree with you. And then the other end of this is, it's a classic example of statutes and rules can't cover everything. You can't write something that's going to cover every extraordinarily unusual circumstance where one might say objectively, if I could write for it, I might have an exception for this one, which makes it so interesting from a legal point of view as to how it will be tried. And what adds to that is, often in that situation, when you get a real outlier that doesn't seem to fit within the regular, normal, way that we think the law should operate, you get discretion in the decision maker and the executive in not moving forward with it, not bringing charges or doing something. Here we have one where the decision maker is going forward in a case that's falling in this area that I am sure no legislator ever anticipated would ever come up and couldn't have drafted for anyway. You can't draft for every crazy situation that may arise. So it really brings to the fore a number of things. And I will be really interested to learn about the prosecutor's point of view here, because what we're getting right now is really essentially the defense end of this, what came out in the trial and whatever. And we don't know what else the prosecutor may have that led to the decision to bring the charges.
Well, when I saw the prosecutor on, like I said, I use broadly the term television, on some clip, I was really surprised on how strongly he was advocating in the media. He said he got out of the car, Spencer, he was referring to, and killed Fossler in cold blood. And that did not strike me as sort of the normal response and interaction with the media that I have come to expect from a prosecutor. So,
particularly since there's no evidence at the scene, the only people who can say what happened at the scene are Spencer and his daughter.
Right. And of course, Fossler, who can't say, right?
Who can't. Yeah. Right. And the camera that no longer is available.
Right. I'm really interested to see whether his daughter is going to testify in this case, because presumably the jury would consider her testimony rather impactful if she winds up supporting her dad after having gone quasi-voluntarily, because I don't like saying voluntarily, but not under, theoretically, we don't know for sure, by the way, but theoretically not under force from Fossler. We don't know for sure, but let's, given the history, that's at least a possibility.
The lawyer I talked to last night was very emphatic that were he to be defending Spencer, he would call Spencer's daughter. And I was thinking, I would like to know a lot more about the emotional psychological impact on a 14-year-old in that situation, testifying and having to endure whatever the cross-examination would be in a circumstance where it appears, we don't know, that there was no force used, that the relationship, let me put it in heavy quotes,
Right.
may have lasted for a while, that she appears concealed it from her parents, and that she may have gone with him without fighting the night of the killing. It seems to
Right.
me that's a heavy load to put on a child.
Well, moreover, the most important question, you're entirely right on every one of those aspects that you want to consider, but let's not avoid the obvious. What's she going to say? Meaning, if she says, oh, Spencer got out of the car and shot Foster in cold blood, then you don't want to put her on if you are the defense attorney, right? You want to diminish her testimony if the prosecutor puts her on. Or seeks, you may call her preemptively, but your point is that this attorney you spoke to said that he would want to put on the daughter for the benefit of Spencer. We need to know what she's going to say before we can draw that conclusion.
Yeah, that's true.
We don't.
That's true.
Yeah.
Well, I guess we will see, unless after what I think will be reconsideration of some of those orders, the prosecutor makes a different decision about the likelihood of being able to get a conviction beyond a reasonable doubt on the evidence that he has. And again, we don't know what other evidence there is. So right now, it is, it's interesting to speculate. And I think it's informative to try to evaluate based on what we know now. But we all have to be obviously clear that we may not have a full picture. And as I said at the outset, I'm willing to believe that's true because it just seems to me that the prosecutor, in deciding to make the decision to bring the case, when his thought process is to be that he's got a reasonably good chance of prevailing beyond a reasonable doubt, and that he's got a sincere belief that it's the right thing to do.
Right.
Yeah. So we'll have to see this. So.
It's a really curious case. I mean, on so many levels, right? How is this a case that the prosecutor is so vehemently prosecuting? What does he know that we don't know?
We don't know. That's right. That's a good way to end. Thank you so much for joining.
Thank you, Joe.
And I hope you will continue to pay close attention to this trial so that we can call on you for your, boots on the ground information. And of course, your expertise.
Well, thank you so much. I'll need to pay a little closer attention to the gossip at the law school so I can report back on that.
Well, you don't have any yet. You've got to start encouraging. You have to be a catalyst there. You just can't sit there as a fly on the wall expecting somebody else to bring it.
Indeed. Fair enough.
Thank you so much. Okay.
God bless. Take care.
So long. Okay. I found that very entertaining, very interesting. I don't know, you may not have found it quite as interesting as I did on some of the legal questions that I just think are really not easy to answer and would provide some very interesting, very intricate legal arguments. And as Bob Steinbuch said, and I agree with him, we may not see some of the answers because as a prosecutor, if you think you've got a solid enough case to introduce something that is undoubtedly going to create an appealable issue, is not something you would do lightly. And that means that some of what we talked about may not be resolved at the trial because it introduces a big question mark on the prosecution side as to whether if they get a conviction, it will stand on appeal or after appeal. So we will see, but I thought it was very interesting, and I had not realized that there are states that permit bringing guns into a courthouse, and that they might be interpreted to say, or a judge might conclude, you can bring the gun into the courtroom. I found that very interesting, let me say. So Tracy Kelman, thank you. I thought he was great too. Uh, I enjoyed him a lot. He seems to be a very, very, not only very knowledgeable and interesting and there to watch the trial, but also very personable and charming and kind. So, are there any questions here before we call it a night? Lee said she thought the legalities were fascinating and in some ways disturbing. Well, disturbing depending on how they might work out, I think. But the point in here is that, like everything else in life, no statute is perfect. And so you always get leakage in a statute in terms of where you would like it to land. And you can never do it perfectly, because if you fix the leakage over here, it's going to leak over there in a way you don't like. So the best you can ever do is to try to consider all the possible ramifications that may come if you set the statute here, and then look to see, well, this possibly might happen as an outlier. This possibly might happen as an outlier, but can I move the fulcrum somewhere else and cause less of the bad consequences that I want? And if I can't, then I put it where it is, recognizing that every once in a while it's going to fall in a place where I don't like the result. That said, I can't move the fulcrum without causing the leakage over here that I don't want. So I've got to be willing to accept that we don't live in a perfect world, and sometimes the results are not going to be good, because if I try to fix the result here, I'm going to open up to the leakage here. Rules have to be enforced regularly. Otherwise, you lose the rule entirely. Okay, so what do I think about laws being fixed by jury nullification? Generally, I think it's a very bad idea, because jury nullification, it comes down through history as a positive when you've got a tyrannical government, bad laws. The people should be able to take that authority into their own hands, but it can translate, let's say in the South, in the post-Civil War, into verdicts against African Americans, notwithstanding what the law says. So jury nullification doesn't have to come out as a positive. So what the system does is it admits that jury nullification is a possibility, but jurors are never told it. So a jury is never told, and if you don't like this law because you think it really doesn't apply and it's really terrible here, you've got the authority, just don't apply it in this case. We don't tell juries that. It may be that once in a while it's what happens. That's why we are never permitted in a criminal trial to inquire of the jury how it got to its result, why it did what it did. We're not entitled to ask the jury preliminary questions, 12 questions, just to see if they were thinking right about it when they got to the conclusion, because we don't. We want to give the jury the independence, and that protects the jury nullification right. But we're not going to tell the jury it can do it. And we're certainly wouldn't expect it to happen in anything but the most extraordinary case. And my guess is that what would happen is jurors would not say, this law is so bad in this case, I'm just going to ignore it. That they would find a way on the law and the facts to say that they were following the law in a particular case. However, they had to shove the law, the peg into the hole, the square peg into the round hole to make it fit. I think that's what a jury would do, rather than to say, we just don't like the law. Jury nullification does have a long and really important history. One of the earliest cases was William Penn, and that was a case of, religious freedom in England. And the law at the time said the greater the libel, the greater the injury, the greater the breaking of the law, which meant the more truthful the statement was against the government, the more you should be punished for it, because the more injury to the government. And the jury just didn't want to do it. So they wouldn't come back with the verdict that the judge said the law required. And they sat there, wouldn't do it. The judge finally stopped sending them in food and water until ultimately the jury caved. And that's an example of an attempt to use jury nullification to what we would say is the highest ethical standard. That's where it comes. But the problem is, once you admit or you recognize it as maybe a regular occurrence, you don't know what it is that the jury is going to think they want to nullify in the law. And remember, the law is a statement from all of us as to what we think the best articulation of policy should be. I know we know legislatures don't get it right all the time, clearly, but we say it's our best articulation of policy, and it's the articulation of policy by the majority. And if you're in the minority and you lose, you shouldn't be able to say, well, gee, I don't like that law because I wouldn't have voted for it. I mean, the society evaporates if that happens. So I'm sorry, I gave you a long lecture to a short question. Do I think Wendy Adelson is going to be arrested? I have answered this over and over again. I think there's enough evidence to arrest her. I think there's enough evidence to bring her to prosecution and convict her, but I think it would not be an easy case, and the jury would have to run all the inferences from the available evidence in favor of prosecution. Okay. Oh, Court Dog said she loves my legal mind. Thank you very much. I appreciate that. Okay, are there any other questions? I mean, this is one we're going to be following, and I hope this has tickled your interest in following this case, because it really is not like all murder cases are different, and of course that's true, but this one really is on a little plane by itself, at least so far from what we can see. Oh, Court Dog Daniel is a guy. Okay, I'm sorry. I should do what I say all the time, he or she. Whenever I don't, it turns out I'm wrong. But I hate he or she. So, oh, no, you don't like long lectures, Benzie, NYC. I don't believe it. I mean, I'm sorry. I'm impugning your honesty, but long lectures, hard for me to believe anybody likes a long lecture. All right, well, we're going to end. Nebraska's in the Elite Eight of the NCAA basketball tournament. So I'm going to stay up really late here in Italy and watch that game. And I think I found a way to watch it. And if I don't, I'm just not going to be happy. But that's the way it will be. Nothing I can do about it. No, I'm not going to do a show tomorrow. And of course, the weekend is the weekend. But I hope I will see you on Monday. Ciao a tutti. Thank you for those who hit like. And if you didn't hit like, why not? It doesn't cost you a thing. You just put your little finger on the little check thing or whatever it is. That's all it is. Thank you if you subscribe. Subscribing doesn't cost you anything either, and you get alerts, and it helps the channel. Hypes really, really, really are helpful. You get 3 a week. You have to do it on a video. So if you would use a hype on one of my videos, I would really appreciate it. If you would use all your 3 hypes, I would be ecstatic. And thank you so much, members who have really invested in my channel. Thank you all. Ciao a tutti. Have a nice weekend. So long.